Thank you very much for coming back. And we're gonna continue now. I'm gonna pass over to Crystal Pennington, who is the CEO and co-founder of NiO RM. She's got up very early because she's in New York to be with us today. So she's going to be talking for 30 minutes or so about NiO RM, her risk management product, and then we'll come back and talk a little bit more about more general topics connected to GDPR. So Crystal, all over to you and all yours.
Wonderful. Thank you, Matt. Hopefully everyone can hear me. We've got some slides, so we'll jump between myself and those slides, but a little bit of background. So I came from the banking institution in the world of governance and compliance and decided to actually build a tool that, are we good, Milo? Perfect. To build a tool that actually would give us what we needed in that space. So one of the interesting parts is GDPR actually really, in and of itself, is an appropriate technical and organizational measure around what you're doing for data compliance. So let's go here. So Matt got into a lot of the details around the rule and everything associated to what data compliance is and that personal data. But there's a couple components around that life cycle that actually every company needs to be concerned with and how they're governing that. Really, you've got to do the identification of the data. Where's your assessment? How are you doing it? Who's doing what? Where are they doing it? How are they documenting it and why? Where are you processing the data? So this ties into a third party, which I'll kind of talk about throughout my entire presentation. One of the biggest risks to our firm right now isn't just how you manage your data, it's those third parties that have your data. And guess what? You are responsible for a third party. Even if you have a legal agreement in place, you actually have to know what are they doing, how are they doing it, and make sure that all of that data that your clients have given to you that classifies as personal data under GDPR is protected. That includes processing. Where's the location? How's it done? What servers? What's the redundancy? What's the BCP? What happens if there's a breach? You've got 72 hours to report. How are you reporting it? How are you documenting it? And then the bigger piece that a lot of people aren't as familiar with if they haven't been in the governance space before is mitigation. And that's the key piece. How are you actually remedying a breach? How are you documenting it? How's the DPO handling all of that? You know, you move into that component of there's the data, but the piece to all that governance is identifying those relevant stakeholders. What department has the data? How are they accessing the data? Who has access to the data? So this gets into access control. And then actually, as you get through the personal data piece, clients have the ability to come to you and say, I don't want you to know who I am. Matt touched on this a little bit about the number, but do you really know that that's him or not him? And then after that, really from a data standpoint, is the life cycle is implementation. How do you implement a GDPR program that covers all of this? Where's the identification? Where is it processed? Where and how are you identifying who has access to it and that anonymization? So here's kind of a timeline. This is general. You can kind of find this anywhere you do any searches for GDPR, where you're at. So I'm going to start with November, just because it's basically where we are today. And that's that assessment piece. So really in the governance space, one of the biggest problems that people run into with GDPR is how do you actually manage that? Where are you doing that assessment? So the NiO Platform is really and truly a top-down risk-based approach. It wants to know who's doing what, how are they doing it, and everything around that. So we've actually partnered with the Virtual Forge. They use this platform to do that assessment. And I'm a little bit biased because I actually think it's probably the best one in the industry that I've seen right now. And it gets rid of spreadsheets. So really your alternative to using a SaaS-based product is spreadsheets. Regulators are moving away from spreadsheets as an alternative to maintain governance. If I was in a position at a firm dealing with GDPR, I would be extraordinarily nervous to not use a SaaS-based platform or some sort of tool to actually do those assessments, right? There's a significant data analysis phase. There's a significant identification of who's doing what, how to assess the details around it. And then you move from there, kind of, you do the assessment, but the biggest component to that assessment is a gap analysis. You've got to document that somewhere. Who are the clear roles? Where are the responsibilities? What is the report you need to produce out of it? How are you identifying everything around that? And that is the storage of the data, right? It all comes down to data. GDPR is all about the data. How are you protecting it? How are you governing it? And again, going back to third parties, how is anyone who's touching any of your data doing the same exact standard that you expect and you're relaying to your clients? Really, that gives you 60 days basically, right? Do an assessment, identify your gaps, and you kind of bleed over into January. So really, if you're doing it on a good timeline to give yourselves plenty of room, get everything into the system, get those assessments, understand where your gaps are, collect all the data, actually do the data mapping, everything around that. Let's say you're getting into kind of January-ish. This is where you have to identify that data protection officer, in-house or outsourced. You do need someone in that role, and that's a critical person. It's a critical person to oversee what's going on. How are they doing it? And also to make sure that the issues that surround GDPR that are kind of the scariest are breaches and the right to be forgotten. So how are they managing those? If there's a breach, how are they making sure everyone knows? How are you relaying to the clients? And how are you mitigating that? So it's really a front to back governance issue that GDPR has presented us with. The bigger pieces around all of that are the policy. So a lot of firms now facing GDPR are learning around what it really means to write a written supervisory procedure. What are the procedures of your firm? Identifying all of the risks, identifying all of the gaps, and identifying where your data sources are and making sure that there's correct policies in place and actually documenting those. So where you move into after all of that is done is the great world of reporting. This is where my platform resides, because one of the things that doesn't exist in a lot of technologies currently is a real-time dashboard. So the problem with GDPR and what they're presenting in the rule is you actually have to be able to demonstrate that the processes are in accordance with the regulation, but they actually are measured to what your firm is doing and where your data is. And as Matt talked about earlier, those identifications of the type of data, what actually classifies, and actually making sure that your data mapping is correct. But you get to the reporting piece. So we always think about reporting, great. We can tell each other inside the company what's happening. If I use a third-party DPO, they can give me reporting. They have transparency. We're all accountable, right? We're on this platform. We're all accountable around what's happening. The reporting can actually be requested by the auditors. So in regulation currently, most of the time, regulators don't ask for your internal reporting. Where's your risk matrix? Where's your risk mapping? If you get audited, they will ask for that. GDPR actually changes the game a little bit. The way the word and the regulation is designed is an auditor can come in at any point or add a snapshot, ask you for reporting. Where are you? Where's the policies? I want to see accountability. Who's responsible for everything around that? So you really have a game-changing regulation that's come into the data space. And then really in the end of that, you get to implementation. So, I mean, we're going to cover a lot of that. But again, this is a really good slide around what you're looking to accomplish. That identification, you've got to govern it, protect, and audit. Now, one of the things is if you use a spreadsheet, this is a really difficult workflow to manage. So the NiO Platform is actually a business optimization workflow tool that we've implemented for regulation and compliance. So my background is supervision. I had 600 traders at one point that all reported to me on 80 markets. So as far as supervision was concerned, I saw every gamut of every regulator and every variety of what they wanted to see. Everything boiled down to a workflow. Who's doing what? How are they doing it? And why? That's the biggest piece underlying GDPR as well. How are you doing it? How are you documenting it? And really, how are you testing it? Which is an additional component, which isn't always resided in the banking world. You do need a third party. You do need a partner in this relationship to actually have your best interests to test, to do cybersecurity, to verify your policies and procedures match up with the type of data that you have, that matches up with your business model, and also matches up to third parties. Where is your data going as soon as it leaves anything on your platform? Because you have the same governance and protection rights that you have to give to all of your clients. If, and let's say everything around that is done, and I think the platform that my company has developed actually meets all of those requirements. So it's actually designed to give you a really good view around accountable, the people that are responsible. You've got supervisory controls in place. You have the ability to see the reporting. So the nice thing with that is you can have an outsourced provider use it, and actually you have a real-time view of everything they're seeing as well, which the regulators are looking for. They want you to also see what everybody else is seeing. When you have all of that done, you get to the fun and glamorous world of audit. So everything that you do to set up your new policies, make sure the data is correct. You've autonomized it. You've gotten everybody assigned to a number. You've done everything under the regulation, which is really fun reading. And I think Matt and I are probably the two people who, read it from front to back a number of times. It's good reading material, but you have to audit it. Somebody internally and externally needs to give you an audit. They need to actually tell you what's happening inside your organization and if it meets the policies and procedures you've established, and spit out a gap analysis. That is and should be something real time. Again, going back to that idea that spreadsheets are kind of a limited function, you need something that's a workflow tool, and you need people that understand how to use a workflow tool to be able to implement it in a really good way. And you're going to actually get that front to back coverage. Where does it start from a data identification to where does that audit end, and everything in between? So if we can move down one more slide. So really and truly, kind of the three things and the underpinning of anything related to governance is you want accountability. You want to know exactly who's doing it. You want to have transparency as an organization. Where is the risk? How am I managing the risk? And how am I doing it actually in a cost-efficient manner as well? To do that, and then simplicity. Let's be honest, regulation and governance and controls are not the funnest thing. No one really likes to do them, except for myself. People aren't as passionate around making sure you have the right governance in place. So you want to do it easily. You want to make sure that the people on your team are able to get the information, have access to the reporting, and that they're engaged on making sure that the organization is meeting the GDPR requirements at the same time. When you do that from a workflow tool, you really want to look at stuff that has a real-time dashboard. You want to look at stuff that's able to report in a very easy KRI, right? Key risk indicators. Where's your risk? Where's the gap analysis? How do you drill down through those KRIs? Where are you having a high risk, a medium, a low risk? Are you able to look at heat maps? I know this is probably for anyone who's on the data side of the world, all kind of foreign speak around risk, but you're going to get very, very familiar with risk and governance as it applies to data. And how much of that can you automate? How much of the platform allows you to push out all of those checks and the governance that you want tested on a regular basis on an automated basis? So it's a whole lot less human touch, and that everything is actually kind of fitting in to exactly what you're identified as a company, as your controls, and where you need that process to be. So this is just a quick snapshot of some of the things from a NiO perspective and where our platform kind of fits into the marketplace. We really actually reside a lot on this ability to automate, to be able to push out various things that you want to ask your staff in an automated fashion, so that as a DPO, or the designated individual, or as someone who has an outsourced DPO providing you information, you actually are getting that on a timely basis. So it's monthly, weekly, quarterly, whatever as a company you determine are the metrics you need a refresh. You need to identify gaps. There's a change in data. You've changed a data provider. You had a breach. How do you mitigate that? All of those things are actually things you can build into a system very quickly, and you can actually not have to do a lot of the heavy lift, and you can spend that time and energy on the other things that actually, make the business exciting and everything around that. With that being said, I'm going to jump to, if we go one more slide down, just a quick view. I've touched a lot on dashboards. So this is just a quick snapshot of kind of where our platform puts things. Really glamorous heat map, which is critical under GDPR now. This is a really quick snapshot. Where are you red, amber, and green? Where's your hotspots? Where's your big gaps? Where do you need to put the most energy and effort to get the right compliance, the right governance? And then everything around that. So you can actually look at where are your issues, what do you have that you need to spend more time and energy on? And then you can use this as well to do any mitigation. So if there is a breach, if a third party does a breach, if you want to actually identify third parties as high, medium, and low risk vendors, which is actually very common for a lot of the banking institutions now. And GDPR kind of falls into that same genre of if you have a vendor that has really personal data and really important to you from a risk management perspective, you can actually have them go in and give you the information, and you can manage that appropriately. So it actually gives you a full transparency and kind of an interesting view on your stack of where all that data is. And everything's got to be a dashboard. So if you look, let's go one more slide down real quick. One of the things too that's very interesting around how you manage GDPR and how you define roles and responsibilities and all the policies, it has to be a measured approach to your business. So it's really great to come out of the box and people are like, we have a great GDPR solution. One of the things that in the marketplace is very difficult, and why I think, I am, of course, partially biased to my own platform, why I think using something where you have a third party doing verifications and why you're using a platform that's a workflow tool with really strong controls is that ability to create your own configurable governance. So your company has things specifically that it needs to meet GDPR standards and meet the regulation deadline in May. Those things you're not going to buy out of a box. You actually have to do a measured approach to get that information. So you can, in the platform, build your own workflow to allow you to build a compliance dashboard that fits your needs. And this is where you can use a third party like Virtual Forge or someone else to help you. You can do it yourself and use them to test it. There's a lot of ways that using a platform allows you to get an interesting view of governance and compliance and actually get you a closed loop perspective around what you're doing and be able to give you comfort when the auditor comes in and asks for everything, that you've actually met the regulation in the best way. Now, the fines are really big. Of course, coming out of the gate, the regulators are saying that they're going to be, gentle and be able to give you information and help you along. But what they're going to look for is that you've actually implemented some sort of governance in a way that is fine-tuned to your business, that you've partnered with the right organizations to look at third parties, do your testing, do your audit, do your internal gap analysis, and everything around that. And that's actually what they're looking for out of the gate. The fines and everything will slowly happen after that. Now, if you do nothing, you can pretty much expect you're going to be fined out of the gate, but that's not what they're looking. They're looking for you to actually do a measured response and actually get in front of the governance and compliance. So, there's existing data laws across the globe, and depending on where you have data, that's going to also cross over into other regulations. But GDPR's big focus is to make sure as an organization you understand where the risks are, that you're managing those risks, and that in the end, you're actually testing that your methodology is going to help protect the end client. The end game for the regulators is client data protection. They are less concerned what you do as a business. They're more concerned that that client has the ability to have their data protected and that the end client is really getting a risk reduction and you're diligently protecting personal data of anyone in the EU. And from a company perspective, you're improving compliance, you're avoiding fines, you're doing everything around that. But in the end, that you ultimately are protecting that end client, which is very valuable to you for a business perspective as well. So I think I got 30 minutes. I talk extraordinarily fast on top of the fact that we covered kind of everything. I think, Matt, probably the easiest thing, I can turn it back over to you.
Okay.
From there.
Yep, that's fine by me. Thank you very much, Crystal. Very informative. Oh no, don't want to do that. God. That's a bit weird. Okay, that's better. Okay, super. Am I on mic? Am I good? Yep. Great. Okay, guys. Okay, so I should say that following this session, there will be drinks downstairs in the bar, and I'm happy to answer any questions that anybody has. Well, we will do a Q&A, but I just want to get the bar thing out and forward and front first. Yeah, so Garrett asked me to just do one more slide so we can get down there quickly. Okay, so let's press on then. Looking at some of the other aspects of GDPR that are important. One of the other things that's been introduced is, or has been articulated in a different way, I should say, is consent. Obviously, as we all know, the concept of consent has been around for, in terms of data, has been around for a long time. And the reason that this was, the way that this was expressed previously was in a slightly, as we'll see in a moment, in a slightly vague way. And it's much more precise now. I'm sure everybody's been to a website where you have to tick a box or untick a box. You have to agree to having your particulars used by somebody or potentially being passed on to a third party. And this all comes about from existing legislation. But there's a tightening up here about exactly what this means. So, not surprisingly, you must have consent to capture and process data. Consent must be explicit. So you must be giving explicit consent for information. Now, exactly how explicit depends on the type of data. There is a requirement put my teeth back in. There is a requirement for consent to be extremely explicit where you are dealing with, again, those sensitive areas of data. But you must explicitly give your consent to whatever is going to be done with the data, and it must be very clear what that consent is being given for. So there's a lot of work to be done, I think, from a technology point of view, just on those checkboxes, just on making sure that those terms and conditions and what you're accepting to is clear and complying to. It must be made with a genuine choice. Now, there's a lot of work being done at the moment, and I read something about it last week, which is kind of post-GDPR, but is the next wave of thing coming, which is with the EU trying to completely break down the cookie wall. So effectively, you've all done it. You go to a website and you have to tick to say, yes, I accept your cookies. And if you don't accept their cookies, you don't get anything. You don't go into it. That's something that the EU is trying to move away from, trying to break down the cookie wall, trying to get into a position where you get functionality whether you accept the cookie or not. And from a technology perspective, that requires an awful lot of changes to websites. But also, don't forget, this is not just electronic. This is every time you're giving your data to an organization. Are you actually getting a genuine choice? It cannot be the default. You cannot have that tick box ticked automatically. You cannot have a thing that says, contact us in the event that you want to remove you don't want to be enrolled in this. It must be demonstrable, okay? And this is again, I come back to the technology side, but it's not just the technology side. If we're audited and somebody says, I want you to prove to me random person number 76 gave their consent for you to save their data, how are you going to do that? If you work in an office and you are going to prove you're storing information about Joe Blogs from Evesham, how are you going to prove that you've got permission from Joe Blogs to be able to save that information and store that information? How are you going to demonstrate that? Okay. It must not, should be a not in there, it must not be a contractual prerequisite. And I'll come back to that one in a moment because there is an additional rule there which comes into play when you're hiring people. And so we get to the final one, and this is a big one. It must be as easy to withdraw as it is to give. So I've gone to a website, I've gone to a company, I've said, yeah, you can have my data, blah, 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 blah. A few months later, I'm leaving the company, or I don't want to take that service anymore. Or for some reason, I wake up in the morning and think, hey, wouldn't it be really fun to cause havoc by removing my permission for a particular system? I've got to be able to do that as easily as I gave it. And that's a really tricky one, I think, to implement. The actual process of removing that in some ways is easy once but how do you actually give that information? So that's quite a tricky one. Okay. So let's just look in a bit more detail at this one. Cannot be a contractual prerequisite. Okay. So typically, the way that employers have got away with this, have implemented this before, is in the contract, there'll be a clause that says, and you agree to give us all your data for using whatever we want it to be able to do. Boom. And you sign it, and that's it. And they're covered. That now changes. That cannot be used as, you can put that in there, but in a specific case, for a specific storing of data, you still have to get their specific permission to store that data. Okay? And it must be freely given. That's a requirement now. So in other words, you cannot withhold a contract from somebody if they refuse to give you permission to store their data. That's, again, a hugely tricky one from an HR perspective as well. Okay. Again, though, I think all of these things are way more, they seem much more frightening on the surface than they are under the hood. Actually, what you're talking about is explaining to people what the data is going to be used for, and making sure that they agree for it to be used in that way. And most of the time, it's going to be used for internal training. It's going to be used for policy tracking and things like that. So, okay. And this is another one. So, okay, I understand in the future, I'm going to have to get this consent. I'm going to have to record this consent. I'm going to have to make sure that consent is specific. I'm going to have to make sure that consent is freely given, every little checkbox. What about all those websites that we've already built? What about all those applications that already exist? What about all those policies that we're already trapping data for and keeping data? What about historical consent? Well, what it says about historical consent, and this again is in a recital, you are not required to automatically repaper or refresh all existing DPA consents in preparation for the GDPR. But if you rely on an individual's consent to process their data, make sure that it will meet the GDPR standard on being specific, granular, clear, prominent, opt-in, properly documented, and easily withdrawn. If not, alter your consent mechanisms and seek fresh GDPR compliant consent or find an alternative to consent. So you are not obliged to redo everything, but you do have to make sure that whatever consent has been given is compliant. And if it's not, you're going to have to re-request their consent in there. Okay. Again, we come back to this thing, properly documented, easily withdrawn. Two kind of simple phrases, but very important. You've got to be able to prove that it's the case. You've got to be sure that they can withdraw that consent in an easy way. Okay. So, change. In the DPA, consent has to be freely given, specific, and informed. Under GDPR, there has to be a clear positive action with the ability for it to be withdrawn at a later date. And it has to be explicit, very explicit in some cases. There's one other side to this which is really important, and obviously I have two teenage boys. This is one that you know is a constant source of discussion in my house. Children's consent. Article 8 states that a child under 16 cannot give consent. You go to Facebook now, if I'm 13, I can give consent. Okay? Under GDPR, that's no longer permitted. Has to be consent given by a parent or guardian if you're under 16. However, for some reason, this article can be lowered to 13 in member states if member states choose to lower it. And the UK has indicated that it will reduce it to 13. But if a parent or guardian is giving permission, you also have to demonstrate that permission as well. That also has to be recorded in your process. Who was it who gave permission? So again, a change. DPA parental consent is not required. GDPR parental consent is required. Okay. One of the other things that's very important, and this again is something that's very important anyway, is the security of processing. Again, no surprise here really. This is basically, once you've got the data, how do you secure the data? How do you process the data securely? Are you compliant with the rules and regulations around data processing security? Most companies that process personal data nowadays will have most of these things in place. But again, I come back to the point that I made earlier on about matching of data sets here. So the actual requirement is for the ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. So data recovery is a key thing. It's not just about being able to store it, it's about being able to recover it if something goes wrong. And a process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational measures for ensuring the security of the processing. So basically, penetration testing, data audits, cyber attack modeling, all of those things that you probably do if you're dealing with data. Quite often though, and this is an important distinction from a technical perspective, a project will go live, you'll do all of your penetration tests and so on. A requirement is regular testing, is making sure you're constantly testing that in that process there. Okay. But again, I don't think that's hugely surprising. You also are required to ensure the ongoing confidentiality, integrity, availability, and resilience of those systems. So making sure that the data is available, has integrity, and so on. One thing that people are often drawn to at this point is ISO 27001. which is basically a data security ISO. Now, going through an ISO process is a huge process with a lot of overhead, but there is a lot of things in the guidelines for this which actually are just the sorts of things that you need to put in place for a good, not even for GDPR, but for a good data security process. So just picking off the top things, making sure your assets are managed securely. So making sure, if you have laptops that have sensitive information on them, you have a process for them being locked in. Access control policies to buildings, access control policies to regions, access control policies to different areas, and that can cover all sorts of different areas that you can be a part of. We do a lot of work for a company which builds accreditation systems for large stadiums. Access control policies are a key part of that. Information classification, what I said at the beginning. Know what you've got, know what it's for, know how it's used. A process for dealing with an incident, whether that incident is somebody breaking in and stealing hardware or whether that's somebody breaching your security. Comms management, both how do you articulate if there has been a breach or there's been an incident, but also how do you manage internally, perhaps more importantly, how do you manage internally information about data, information about security, how do you manage that process, how do you manage what Crystal was talking about, the GDPR assessment process, and how do you manage human resources? How do you manage human resources before they start, so vetting and all of that side of things? How do you manage human resources while they're in process, making sure they aren't part of that 75% who are saving their Candy Crush results on the system? And post, how do you make sure that you are not at risk from employees who have left? Again, not all of this is part of GDPR. This is all, though, about this, falls into the kind of bucket of security of processing. How do you make the data that you're processing as a processor, data you're processing as a controller, as secure as possible? Have you got processes in place for all of these? Have you isolated where the risk elements are? Okay. So we come back to this point I made slightly earlier on. One of the ways that has traditionally been dealt with this is people avoid having to take responsibility for personal data because the data is anonymized. And anonymization has become a term that's used very freely. Anonymized data, just to recap what I said earlier on, is where you've taken a row of data, you've cut out the first name, last name, email address, and it's anonymized, sort of. So this is again so this is another example here. If an organization collects individual travel movements, the individual travel patterns at event level would still qualify as personal data. Think about the example I gave from MIT, the analysis that was done there. You can actually track people really simply like that. If it's aggregated and you're only saying something like, on Mondays on trajectory X there are 100% more passengers than Tuesday, that's not personal data. But that's a really important distinction that, the raw data is exactly the same. It's about what is it that happens, what is it that you're using that data for? And again, there's an important distinction here. If I still have that raw data, even though I'm using it to create that output, that's still personal data. I still own that. I'm still responsible for that process. Okay. So the GDPR introduces a new, well, it's not really new, but in legislative terms, it's a new term, which is, it's really hard to say, pseudonymized data. So this is data where the user cannot be got from the data itself. It can be used by joining additional data sources. And this is what is often meant by anonymized data, because it's actually really hard to truly anonymize data. And the reason this is important is because demonstrating the pseudonymization of your data is something that will move in your favor if you're audited and assessed by a compliance authority coming into situations. So the kind of rule of thumb is, where possible, you should pseudonymize your data. You should try not to store names and surnames and things like that. However, pseudonymized data still falls under GDPR. It's likely to mitigate some of the penalties. It's likely to be best practice in terms of how you work with it, but it still falls under GDPR. Only truly anonymized data does not fall under GDPR. Okay. And I'll skip this slide because this is a bit of a technical one on different ways that you can pseudonymize data. I'm happy to talk about these in the bar afterwards. So nobody else will be. I'll be sitting there in the corner of myself going, oh yes, deterministic encryption, I love it. Okay, so a cautionary tale. Again, this is one that I mentioned earlier on. 95% of the population could be singled out with 4 different location points, 50% with 2 different location points on there. And here we go. This is a really interesting one. So this is a study which was called robust sorry, I've lost my page. A robust de-anonymization of large data sets. So this was a study, again, a study which is available online to read. On October the 2nd, 2006, Netflix, remember them, who at that time were the largest DVD online rental service, they basically offered a prize. So this is before they became the streaming giant. They offered a $1 million Netflix prize for improving their DVD recommendation service. And in order to do that, they basically published a data set containing 1,480,507 movie ratings created by 480,189 Netflix subscribers between December 1999 and December 2005. So that was about 1/8 of their subscriber base at the moment. Okay. On their website, there was a question under the frequently asked questions, and the aim for this was to provide the movie ratings that individual people had given. They were anonymized in that users' names were removed. One of the frequently asked questions about this was, is there any customer information in the data set that should be kept private? Netflix answered the question saying no. All customer identifying information has been removed. All that remains are ratings and dates. This follows our privacy policy, which you can review here. Even if, for example, you knew all your own ratings and their dates, you probably couldn't identify them reliably in the data because only a small sample was included. The guys behind this study then ran a survey, an analysis. They were able to identify through this process 89% of the people involved. They were able to link it to the publicly available IMDb database, where people had posted in forums various things, as well as other things. They were able to successfully pick out, back from that, the doctor responsible for the medical records of the Massachusetts governor at that point in time. They were able to analyze things like this is one example. They're able to take one, for example, and analyze based on his strong opinions about Fahrenheit 9/11, power and terror, Noam Chomsky in our times. His religious views can be guessed based on his low ratings of Jesus of Nazareth and the Gospel of John. He did not like Supersize Me, and both items that we found with predominantly gay themes, bent and queer as folk, were rated 1 star out of 5. And so on and so on. So they were then able to build up quite a good profile of this is just one example. They did it to hundreds of people from there. And this is all from a supposedly anonymized set of things. So that's another good example of how hard it is, really hard to anonymize data. And there are lots and lots of surveys done of algorithms and data set matching where you can see how data sets are linked, especially, and this is pre all the social networks and so on, well, not pre, but early days of the social networks and so on. So, 2006, if you think about it, we're 11 years on from there, that much more data, that many more data sets are out there. The other example, of course, was another one from, just to give you one other example, which was AOL Online. AOL Online in 2002, I think. Or maybe 2004, released 650,000 unnamed users. So basically what they did was they set up a new website, research.aol.com, which listed 20 million search queries, theoretically anonymized, but they were then able to be backported, analyzed, and build up again identities and quite detailed profiles of those people from those search terms, which they then took down. AOL's response to this was a screw up and we're angry and upset about it. It was a mistake and we apologize. But you can see how people got there. I can see, we take out the names, how's anybody going to know? Okay, so just to be aware of those things. So one of the key things is a term and a phrase which is used in the GDPR legislation a lot is privacy by design. So the idea here is that you have everything that you do should be designed with privacy in mind from the get-go. And there's a very good, and it's actually referred on the ICO page, it actually refers back to this, which is Privacy by Design Primer from the Privacy Controller of Ontario. It's an interesting document that you can download and read. And there are 7 steps to privacy by design. Be proactive, not reactive. Be preventative, not remedial. So in other words, all the time, you should be proactive in what you want to do. Don't wait for privacy risk to materialize. And don't treat privacy as a finite item once a process or a application has been built. It's a constant process that has to be renewed, rebuilt, reviewed, and built into things. Privacy should be the default setting. You should never have a situation where people's default setting, and this is now illegal, where privacy is not the default setting. Everything should be private at the beginning, and you have to make changes to enable visibility. Privacy should be embedded into the design. So in the way that the application is designed, or the policy is designed, in the way that the application works, it should be designed to be private. You should never be designing something where you're exposing more information than is absolutely necessary. If you are looking at a graph and showing, if you're looking at an aggregated table, if you're looking at a table and you're showing statistical information, do you really need to see the names of those people, or do you need to see just an identifier to follow through? Of course, the answer may be yes, I do, but that should be the thought process that goes in there at that point. Full functionality, positive sum, not zero sum, cookie wall, basically. Saying, again, you shouldn't have to sacrifice functionality in order to, functionality and privacy should not be a trade-off. You should be able to have full functionality without sacrificing your privacy. I think that's quite a difficult one because when you look at social networks and how they work, I think the challenge that they've got to overcome is quite large. End-to-end security, full lifestyle protection. What that means is you have full protection at the point at which you join the site or the policy or the company. Your data is not being used for anything other than you are totally happy with, as we've articulated. But then you know and have confidence that if you leave that, if you're removed from it, if you want to stop using it, you are actually fully deleted and fully removed. And we all know Facebook in the past, there are lots of different organizations where, and in most large organizations, when you leave, if you wanted to be sure that your data was being removed, pretty sure that it's not being removed. Whether that's by design or whether that's by whatever is not the case, but that's there. Visibility and transparency, keep it open. Make sure that it's always obvious what is being stored. Make sure that it's always obvious who is having access to this data. Make sure it's always obvious how to remove your permission, your consent to be able to do these things. And then finally, respect for user privacy. Keep it user-centric. Make it focused on the user and make sure that you're always respecting their requirements for privacy. Now these are quite nebulous. But the actual document is about a 30-page document, goes into a lot more detail about how to actually implement these. And following these 7 principles is not a requirement of GDPR. Designing your application and policies to be private by design is a requirement. So, this is just, and this is from 2013, so this is kind of going back a bit, but it's the way in which people, and a lot of the information, the literature on the subject, is all about people in the last 5-6 years looking at what the real world privacy issues are and articulating different ways in which you can try to deal with it. So, DPA is all about best practice, things that you should do. GDPR systems must, or must, in fact, be designed with privacy first. They must be designed with privacy first. Okay, two more little chunks of themes before the bar. One thing that's been spoken about a lot, and I think is a really big impact to companies of all sizes, is the right to access data. But interestingly, and I just want to make this point, that this has existed right back to the very first legislation that I spoke about. Under Section 4 of the Data Protection Acts in 1988 and 2003, you already have a right to obtain a copy, clearly explained, of any information relating to you kept on a computer or in a structured manual filing system or intended for such a system by any entity or organization. Where personal data relating to a data subject consists of an expression of opinion about the data subject by another person, so for example, like a report or an appraisal that's been written about you, the data may be disclosed to the data subject without obtaining the consent of that person to the disclosure. So hence you can ask for your medical records whenever you want them, for example. But that's a huge thing. And actually, I would put money on that being technically impossible for a large number of organizations at this point. And that's also part of what GDPR requires. It requires the following. The right for me to be able to access my data. Same right as before. So I can go to anybody with whom I have stored data and I can say, I'd like my data. I want to know what you're storing about me. So again, privacy by design. Why don't we build something that tells you that in the application itself? Why don't we, why don't we actually make a point of proactively sharing that information? Because I can tell you as a technologist, to go back retrospectively and find that information in a system that hasn't been designed for that can be quite a challenge to do. The right to correct data. I mentioned this right back at the beginning. You have a right for your data to be accurate. So if I come along and I see that somebody has made a typo, most likely me, has made a typo entering in my information, I want to be able to go back and change that information, and you have to change that information, or I have to be able to change that information in the system. I think in a lot of cases that's probably in there anyway. The right to be forgotten. So I'll come back to this one in a moment, but the right to be forgotten, this is one of the headline things about GDPR. This is the one that people talk about a lot. It's really important. If you come to me and you say to me, you know what, Matt, I don't like your system, I don't want to be in it, I want you to remove all reference to me from your system. I am then obliged to do that. I can do that in a number of different ways, you know, and I have to show that I can do that. I can do it by deleting a record directly, but as anybody from technological side will know, that's not that easy. I can do it by shredding your files. I can do it by anonymizing your data if I can prove that it's truly anonymized. But that is a definite challenge for a lot of organizations. I have the right to restrict data usage. This is one that I think is actually almost as challenging. Now, this is a situation where you're asking me to give you, you're asking me for you to give me, I'm asking you to give me the data. I want the data. And I'm asking you to use it for process A and process B. I'm asking you to give it so that I can enroll you in this training course, and I'm also asking you to give it to me so that I can send you mails out for future things. That's an easy one. I can say to you, no, I'm happy for you to have my data for the training. I don't want you to have that data for the mailing out. That's an easy one. But what if it gets more granular? What about if I'm saying, you know, I want you to use my data, and I'm going to use it for enrolling you in this training course, and I'm also going to enroll you on this supporting online system that you need to use. What happens in that situation where I don't allow either or? I only want to allow one of them. Now, actually, of course, you can stop them being, at the moment, you can stop them having access to the system at that point because they haven't given you sufficient permission to be able to do that. But again, as the movement is more and more towards not having cookie walls or not having restrictions in place, that's something that's likely to become more and more of a challenge. Right to data portability. I'm going to go to you and I'm going to say, you know what? I know you've got all that data which is in this is in this system, all this data about me which is in this social network, but I actually don't want to use it on that one. But what I want to be able to do is take it and I want to give it to this one over here. Data portability. I've got to be able to take my data from one system to another system in some form or another. Okay. So let's just drill down into a couple of those. The right to be forgotten. Where the personal data is no longer necessary in relation to the purpose for which it was originally collected or processed. So again, this is all about data retention, making sure data is not retained beyond its useful lifetime. I have a right to be forgotten when I withdraw consent. So if at the point I say to you, you can't collect any more data, I've got a right for that data to be removed. I've got a right to be forgotten when the individual objects to the processing and there is no overriding legitimate interest for continuing the processing. Overriding legitimate interest is in the interests of criminal investigation, national security, that sort of thing. So if I just object to it because I'm having a bad day, the personal data was unlawfully processed, well, that's not hugely surprising. Except, otherwise in breach of GDPR. In other words, I didn't get consent in the correct form. So there is a real piece there. The personal data has to be erased in order to comply with the legal obligation. Third parties with whom you have shared the data must also be informed. And the reason I put it in flames is because it's a big one. Basically, this is a situation where I've taken your data and you've ticked the box that said, yes, yes, you can market it to third parties, blah, blah, blah. And I've then sent it out to 56 mail-in companies who have been spamming you non-stop. So you've gone back to the original company and you've said, yeah, you can't share my data. I'm withdrawing your consent for that point. At that point, I'm then required to inform those companies as well. How do I do it? Well, I better make sure I know what I've got and what it's being used for, because those are the things that allow me to track this back. That DPO that we hired 6 months ago thinking they won't have much to do, not the case anymore. So, very importantly, there's also a change now, because if you remember at the beginning, I said that you currently have the right to get that information that you know about. In the current legislation, you can request your data from me. I can take up to 40 days to respond, and I can charge you £10 for it. In the new legislation, I've got to respond quickly. The maximum time I'm allowed to respond, there is a little get out clause which allows 2 months, but basically the maximum time I'm allowed to respond is 1 month. I'm not allowed to charge for that process. So basically I have to provide that information to you with no charge to you in a month or sooner. Okay. I should also just mention here the right to data portability. You don't have to be able to communicate between different systems. You have to provide the information in a machine-readable format that can be used by somebody else. So what that really means is I would export my data as a CSV and then I can hand it on to someone else, and it's their problem about how they ingest that data. Okay. So how do you solve these problems? Data directory or registry, as I've said right all the way along, make sure you know what you got, make sure you know how it works, make sure you know how it's processed. Automated provisioning of responses, data privacy by design. Design your systems so that people can self-service some of this information. It's a lot better to do it that way because if you don't, your overhead is going to be, I mean, because if you think about it, you've got the people with the legitimate causes, but you've also got there was a report done, which came out this week, in fact, about ambulance chasers, which is companies, legal firms who are sensing a huge opportunity here, just like they did with being able to get insurance premiums and so on. So basically, a huge opportunity, even if I don't want that information to be returned to me, there is a massive opportunity for companies who are less than scrupulous to cause a lot of trouble and make a lot of money just by trying to test the system against this as well. Automated provision of exporting data in a common and machine-readable data format, making sure, quick win here, making sure that data can be taken out as a CSV to be shared. But remember, of course, if you take your data out as a CSV, you are still responsible for that data until such point as it's been deleted. So you better make sure that CSV is transported securely to the end user and not by some kind of less secure mechanism around. And also, something to consider here, which is a much bigger conversation than we have 20 minutes left. What if that data impacts more than one person? How do you deal with it if one person wants the data back and the other is saying, no, keep it private? Lots of things there. Okay. Okay, only 4 more slides, you can relax. If there is a data breach, whether you're a controller or whether you're a processor, if there is a data breach, you are now legally obliged to inform the authorities in the event. Ideally within 24 hours, maximum 72 hours. You have to inform them of the nature of the breach, the number of people, and this is a physical breach as well, like a burglary, as well as a data. The nature of the breach, the people who were impacted, the categories and number of records that were impacted, the contact details of your DPO, or if you don't have a DPO, the primary contact in your organization, description of the consequences of the breach. We've lost all the data. What does it mean? It was the medical records of 75,000 people. Ouch. Description of measures to take in to deal with it and mitigate the breach. So what it says, basically, how have you dealt with it? What are you doing to rebalance that, and so on. So this is also a change. The DPA is not mandatory in most cases to notify the breach. It is in certain circumstances, but it's not. GDPR, it is mandatory to notify the breach. Who you notify depends on your contract between the controller and the processor, but the controller is obliged to notify the legislative authority who has oversight of them. So, on the whole, there are a lot of changes that are coming through with GDPR, but actually, when you look at the real legislation there is today versus the legislation that is being changed, many of the things are actually in force or are technically on the statute books at the moment. The biggest changes are, of course, the emphasis on the processor of data rather than just the controller of data, are the changing requirements for consent, and also the right to be forgotten, and the fact that your personal data definition is, and this is not so much a consequence of the legislation itself, but is a consequence of the way that technology and big data has moved. You're now dealing with direct and indirectly matched data sets being treated as personal data. So there's a lot of things in there. But the processes are no different. Protecting your data through encryption, protecting your data in transit, being able to know what data you've got, all of those things are exactly the same. So I'd like to wrap up. I'm going to throw it open for Q&A in a moment, and then Marco's going to say a few closing sentences. But I'd like to just say, obviously, from our point of view, we're here to disseminate this information. We're here to have a drink with you in the bar. Obviously, we're also here to discuss if anybody's interested in taking our services any further, whether it's in the data sphere, whether it's in the cybersecurity sphere, testing sphere, or even our development and cloud services sphere. You know, we'd very happily discuss those, either myself, my business partners, Tristan, and Garrett. We're happy to discuss those with you as well. We're happy also to discuss in the bar any other specific GDPR questions that you have that don't fall into the Q&A session. So with that in mind, I'd like to throw it open to you to ask questions and answers. As I say, I come from a technology side rather than a legal side, so if they're highly detailed legal questions, I'm not going to be able to answer them. But from a technology and from a compliance point of view, I may well be able to. So questions from anybody? Anybody has any questions?
Just a quick question. So if we have people sending in information sort of into an email, for example, like a CV or personal details like that, whose responsibility is it to sort of gather consent?
So I think if you've got some, well, are you doing it just through an email or are you doing it through a website?
Email. So we have an email address on the website.
Okay. So I think I think this is one that you'd have to check legally, but my understanding would be that if they are choosing to send the information to you and you've got your T's and C's, then you have complied with the requirement. However, what you do with that CV and all those CVs once they're actually in your purview, that's a different matter. You know.
Sorry, can I say something, man?
Of course you can, Michael.
In that case, you should have a framework in place when you receive a CV. The framework in place that automatically responds saying, well, we received your CV. If the process doesn't go any further, we are keen to receiving a message from you saying we have to delete your data from our database. Okay? So you have the power to decide whether or not the company shall have your data stored. Okay? So, but these particular changes that are happening with the GDPR is something that many organizations don't don't have in compliance still and need to. So it's so small, so particular that they are not paying attention, that they have to have compliance.
Okay, brilliant. Thank you. Other questions? Gentleman down the front here? Oh, run, Riley.
Hi, great presentation.
Thank you.
So I remember the slides you showed, I think it was the data register, where we're going through and we're talking to all the data processors.
Yep.
And we're saying, what do you do? What data do you process? Where do you store it?
Yep.
And that sounds like a good way of making sure that we document the process and understand it. I've had some vendors contact me saying, that's not enough, and I should buy a tool that scans my file system looking for personally identifiable information because it could be hidden there somewhere and someone might not have put it down properly. And if I don't buy this tool, then I could be in breach of GDPR. I wonder if you'd heard that one or you have any views on that.
So I mean, I suppose they're right to the extent that, yes, if you've got some personally identifiable information that's stored away somewhere that you can't find, you know, then you need to try and find it. But whether or not buying an off-the-shelf tool is going to enable you to do that, rather than getting the people who work with the system sitting down and talking to them and just collecting that information, you know, I think, and also I think as Crystal said, out of the gates, they're not going to be chasing down and trying to harass people. They're just going to be kind of looking to see that people are trying to comply with the system. So, you know, I think. Where I think tools are useful is if you have a massive set of different data sets and the effort of manually collating that information is so much vaster than, in terms of cost, than the cost of getting a tool and getting it in place, then I think there's value to it. But I don't think just having a tool or not having a tool is going to make you any more or less compliant. I mean, because actually the reality is for you to use the tool to scan that information, you've got to have a pretty good idea that there might be something there anyway. And so, you know, I think there are limited benefits to that anyway.
No, thank you. One more question.
Yep.
The right to delete.
Yes.
Obviously, that does introduce some challenges.
No kidding.
Because how far does it go? And I mean, is this one of those areas where people are saying, you know, best endeavors?
Yeah, again, I think it's more a case of, you know, what are you showing that you're able to do? I mean, I do think it will get tighter and tighter. And I think it's largely aimed, I mean, the place that it comes from is clearly the big Facebooks and the big organizations where, you know, when I was 13, I put something online that was really stupid. Can I have that removed? I mean, that's the kind of, and that's the target. But equally, you know, there is a legal obligation to show that you have, tried to delete that data, or you have a process for deleting that data. You know, and I think there's also likely to be a recognition that this privacy by design means that future applications that are built will be built with the ability to delete in mind. You know, I think everybody would accept that there is a colossal amount of work that would have to be done to lots of legacy applications to be able to truly bring it down from that.
Thank you.
And organizations don't necessarily have to delete the data. So the 30 days period to respond to a request only mandates that, okay, we are looking at it, we will get back to you as soon as possible. Obviously, this has to be a short time afterwards, but if you are protected legally, or if you have a lawsuit ongoing, or if the data that the data subject requests to be deleted for somehow poses some friction to your business operation, well, you can either say, well, we can delete it, but you have to be erased from our database, or you have to be no longer a client of ours. Whereas it actually gives back, on the other hand, it gives back power to the data subjects, as penalties are not the only thing that companies should be cautious with. Also lawsuits that the data subject may pose against the company if he feels somehow that they are not abiding their rights, which is actually now new to with the GDPR as well. So they actually pose a lawsuit against the company. So it's kind of a balance in between, try to be as much respectful to the regulation as possible, but still assure that you keep the levels for the business operation to keep. I don't know.
Yeah, I think
Can I
that's.
just add to that as well?
Please do.
So, of course. So this comes back into the right to be forgotten is inextricably linked to your data retention periods as well, because anything that's not relevant should actually be deleted from your systems or purged or pseudonymized. And I think just coming back to the right to be forgotten, the legitimate interest argument. If you are, for example, a fraudster, obviously you would want to exercise your right to be forgotten, but your legitimate interest is to enhance the financial services sector, to make sure that that information is available to us to prevent any crime going forward. So you mentioned the crime, but equally there is an argument to talk about credit risk. So a lot of people don't always think credit risk is an issue, especially if I've got a history of bad credit. I don't want the bureaus to hold my data anymore, so I want to be exercise my right to be forgotten. So there are actually some very, very key considerations that the companies need to consider as why do I need to hold that data? It comes back to the reasons behind it. And it's not necessarily just particular to their own company, but what impact does it have if I delete that data to people I share my data to, like the bureaus? Does it therefore impact the integrity of the other ecosystems around me? And I think legitimate interest does impact that as well. So it's just
a good point. Interesting. Thank you. Okay. Other questions? Any other questions or comments or?
I work for an exams board,
Okay.
and we have about 150,000 children a year going through our records. I hold, therefore, that personal data. How do I go about handling the consent from the parents for all that? It works through teachers. Teachers enter the candidates for exams. Am I allowed to take the teacher's consent to hold that personal data?
Yeah, I wouldn't like to answer that from a legal perspective. I mean, what I think you'd probably find in that case is that there is an assumption of consent in that particular process, and I would assume in that particular case that actually that assumption of consent would be all right. But it's a really good question, and I'm not sure that I can answer that particular one.
The other end
but
of
you're
the
not
scale,
going to be the only people facing that question.
Yeah, the other end of the.
Yeah. Yes, that's good. So it's a good. Yeah.
It's not a written exam. The other end of the scale is that the Department of Education asks for data on children and their achievements, and that is personal data because it's identifiable, even down to the location of where they live. I've asked the question as to what their legal right is to demand that data, and I can't get an answer at the moment.
That's interesting. Because I actually would have thought that was, because although it's the Department of Education, it's not actually specifically the parents have given authority to the school, but they haven't. I mean, maybe there is a kind of rising of authority, but yeah, that's a very interesting one. I mean, that's
legal questions.
Yeah, sorry. I know.
Sorry, there is actually some guidance specifically. There is some guidance specifically for schools and education bodies, which it might be. I'm not particularly familiar with it because I'm not in that sort of sector, but I know that it exists, and so it would be worth doing some research online and actually finding out, and also contacting the ICO because they do actually provide specific guidelines for schools and education authorities. Yeah, but they will be. I mean, they are releasing guidelines, as they go along.
Yeah, that is right. So when in doubt, always contact the ICO, and this most definitely would be a case for you to reach out for them, and aware whether or not are they authorized to ask for what they are asking for, So.
Interesting. Okay. Okay. So, do you have anything you want to say?
I don't know if does anyone have any other questions or. Well, it's just a quick wrap up before we go to the bar and have a gin and tonic. Well, Matt, thank you very much, and Crystal, I'm sure you are still listening to the session for summing up so good, huge and extent amount of information over the GDPR in, I don't know, 3 hours, 4 hours, maybe top. So
I think 3. 4 would be.
so obviously there's much more information to be aware of, but our company can help you achieve the level of compliance in order to meet the GDPR requirements. So we basically have a free 4-way process to do that. Well, first we do a pre-assess questionnaire where we basically run through all your departments and understand what are the levels of procedures that you have in place in order to meet the regulation. Are you aware of that? Are you aware of the regulation is enter into force next year? So we basically just have an idea the amount of work and estimate what we will need to do in order to achieve that. Then we go to what I call the roadmap to compliance, and it's a breakdown in 3 phases. The first one is the audit phase, where we basically have our audit checklist, and we will assure and we will aware what you have in place, but more thoroughly in terms of what do we need to assess and prioritize. And this comes to the risk assessment part, where we will document everything that we have audited before and prioritize the risk that you are facing towards the regulation. And then it comes the action plans, where we basically put in place everything that is around the governance and compliance, but also, if necessary, some security and I don't know, technology that you need to put in place to be compliant for. But it may happen that you don't need everything, and you just need a company to help you with the security part, making your infrastructure more resilient and solid. Well, we can also do that, or we can only help you with the audit and the risk assessment phase. Just to finish, we basically want to help you achieve what you need to achieve in order to meet the compliance. We don't want to scare you. We actually want to accompany you in the whole process through the GDPR and yeah, basically it's that. No. So if you have any questions, and if you have I don't know, anything that you want to discuss further, we can do it at the bar, and I hope to see you there.
Great, brilliant. Thank you, Marco. So the bar is on the ground floor, isn't it? Right down the ground floor, yes. So if you'd all like to decamp there, fill up your glasses, we'll see you down there in a few moments.